Members, if the House will come back to order. Members, if you'll come to the floor. We're going to move on with the rules calendar, but I need to ask the members of this House to come to the floor and go to your desk. Cease conversations just for a moment. I need to make you aware of something. Ask them to come in from the ante room, please, Mr. Leader. Members, I'm going to ask you to stand with me because I'm going to ask you to all have a moment of silence and a word of prayer. I'll wait just a minute for folks to get to the desk. So evidently, just a short time ago, Retta Mumford, Gerald Green's sister, had come home from work and she was checking her mail when she was struck by an automobile. So you can imagine how upset our dear friend is. We understand that she is conscious and breathing. They're getting ready to life flight her to, I'm not sure where from her location is, if it'll be to maybe to Columbus or to Albany or where that. So we'll find that out shortly, I hope. So if you will, if you'll bow with me, and let's offer multiple prayers for Rita and for Gerald and that family. Let's pray. Father, we ask that you would wrap your loving arms around Rita, around the family. Lord, give them peace, give them comfort, Lord. Maybe that will give her healing, Lord. We ask your blessings upon them. We ask your comfort upon them, Lord, and we implore you, Father. We will ask that you heal this lady. Make her whole again. Lord, thank you for your love for them and your love for us. Amen. Thank you, members. As information becomes available, we will let the members of this House know just what's going on. We're going to bounce around a little bit. We're going to move on to a supplemental rules calendar that the chairman just put together, and we're going to bounce back to our original calendar, and we're going to move around a little bit, but we're going to take up some more bills before we call it a day. Mr. Clerk, would you read the caption of House Bill 1268, 1268?
House Bill 1268 by Representative Burchetta, the 176 and others to be entitled an act to amend the official code of Georgia annotated so as to revise, modernize, correct errors or omissions in, and react the statutory portion of said code is amended and further so the work of the Code Revision Committee. This bill having referred to the Committee on Code Revision, that committee recommends that this bill do pass.
Whip Burchett is recognized to present House Bill 1268.
Thank you, Mr. Speaker. Colleagues, I bring before you a very exciting bill. Many of us who serve on the Code Revision Committee every year, for hours we toil over what needs to be done in our code to assure that there's accuracy and that it's organized. And every year we pass a code revision bill, and that's what you have before you in House Bill 1268. It's LC 394848. There's no substantive changes to the code. This is just correcting of sections and numbers and removal of obsolete law. There's nothing here for anybody to disagree about. Well, I shouldn't say that. Somebody probably could disagree about something in here. But generally, there's nothing in here that can be disagreeable. And I'm asking for your favorable consideration. With that, Mr. Speaker, I'll yield the well.
You did a nice job. I almost dozed off, but it was exciting. It's about like the state of judiciary, but we'll go on from there. Love those guys.
Mr. Speaker, I forgot to tell you how I became chairman of the Code Revision Committee. I missed the meeting, so I became the chairman of the committee voted by the committee members.
I can assure you, you deserved it. You have no questions. I think we both need to shut it down, yeah. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? Have all members voted? If so, Mr. Clerk will lock the machine. On the passage of House Bill 1268, the yeas are 168, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption of House Bill 1310,
House Bill 1310 by Representative Ford of the 170th and others be titled an act to amend Article 3, Chapter 3, Title 50 of the official code of Georgia annotated relating to other state symbols so as to designate cotton as the official state fabric. This bill having referred to the Committee on Special Rules, that committee recommends that this bill do pass.
The lady who knows a little bit about cotton, Representative Jacqueline Ford, is recognized to present House Bill 1310.
Thank you, Speaker. This bill just really highlights the economical benefits of cotton as well as the health benefits. When I brought this up, everybody was like, that hasn't been done yet. Texas is the only state who has done this, and Georgia is second to Texas in cotton production. So this highlights that, cotton is hypoallergenic, and wearing it reduces skin irritations. It's recommended by dermatologists. It also prevents the addition of harmful microplastics in our air and our water that synthetic fibers leave behind. And also, as far as the economical impacts, cotton is grown in 100 of nearly, anywhere from 95 to 100 of Georgia's 159 counties, and it contributes over $3 billion annually to the state's economy. And I know that there's 56 gins in the state of Georgia, and as well as multiple warehouses. And so this bill is really just to increase awareness and try to force the markets to offer more cotton options in our daily wear. Right now, we are wearing 20% of what we wear now is actually from natural fibers. So 80% of what we wear are synthetics, microplastics that contribute to environmental issues. So with that, I would welcome any questions.
Lady has a cotton to your right. Chairman Meeks in the corner.
Thank you, Mr. Speaker. Does the gentlelady yield?
I do.
Number one, thank you for the bill, but isn't it also true that cotton is the only sustainable fabric that is on the market today?
Yes, the man who grows cotton knows of which he speaks.
And is it not further true that synthetics that fuel is used in the making of synthetics, and therefore it is less sustainable than that of cotton?
Absolutely.
Thank the gentlelady for her bill.
Lady, yield for a couple more questions, then we do have a speaker. So we'll take a couple more. We have some bills to get to today.
Okay.
Representative Schofield, to your right.
Does the gentlelady yield?
I do.
Is it not true that I've been working on trying to get this issue for plastics and all of these toxins that are in our clothes and our products for a long time?
Yes.
So I really thank you for bringing this to the floor.
I look forward to working with you.
I got it. The fabric of our lives, cotton, no doubt. The lady has no further questions.
Thank you, Speaker.
Ladies yield to the will. Representative Al Williams. This will be interesting, I'm sure. The gentleman is recognized.
Thank you, Mr. Speaker. I rise to support this bill, but to explain something. To many of you, it's very hard for you to understand why would anybody say something bad about cotton? Well, you've had to walk a mile in the shoes of those who cotton has a very sad and bad story about. And we understand that, and I just ask that you respect that. We have children that had to ride down the roads while their daddy pulled a cotton sack down the roads. But here's the other side. This is a cotton shirt I have on. It's a cotton jacket. There are a lot of good things about cotton. And I can't help but think when I came to the legislature, I sat about halfway back near the door next to Lynn James, one of the dearest friends I ever had. And Lynn James literally became a millionaire, and part of that was for the amount of cotton he sold through the years. Fact of the matter is, there are a lot of African-American cotton farmers, and they do a great job with it. And I'll be frank with you. If I got a problem with something, I wouldn't wear any part of it. It's about like casinos, my friends. And I'm liking it to cotton. If you don't like casinos and you don't like tobacco, then you shouldn't accept anything that the tax revenue gives to you. If you don't like cotton, don't wear it. If you don't like gaming, stop using the Hope Scholarship. There are 2 or 3 sides to every story. I just want you to know I support this bill because cotton, in spite of some of its history, has brought economic success to many folk that I love dearly. With that, Mr. Speaker, I can go on much longer, but I know you want me to hurry. It's getting late. I yield the well.
I tell you that'd be interesting. I'm going to break protocol here and tell you all about Gerald's sister. She has a broken pelvis, but she's stable. They're going to take her either to Dothan or Columbus is where the best place for her to be treated. So that's good news, I think, even though it's not great, but it's not what we were concerned about when we first got the call. So keep Gerald and Retta in your prayers, please. Thank you for letting me inject that. That concludes our discussion on House Bill 1310. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All of those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? For what purpose does Representative Carter rise?
I'd like to be excused according to Rule 133.
The lady has that right, and the journal will also reflect. For what purpose does Representative Dickey rise?
Parliamentary inquiry.
State your inquiry, sir.
If we pass this bill, will we be able to wear blue jeans in this chamber, Mr. Speaker?
I'll check the rule book. But we're leaning that way, no doubt. Thank you for the question, Mr. Chairman. Have all members now voted? All members voted? If so, Mr. Clerk will lock the machine. On the passage of House Bill 1310, the yeas are 158, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption of House Bill 1230, 1230?
House Bill 1230 by Representative Todd Jones of the 25th and others to be entitled an act to amend Chapter 1 of Title 6 of the Official Code of Georgia Annotated relating to general provisions regarding aviation so as to prohibit the operation of unmanned aircraft systems over a place of incarceration. This bill has been referred to the Committee on Technology and Infrastructure Innovation. That committee recommends that this bill do pass by committee substitute.
Chairman Todd Jones is recognized to present unmanned aviation. Sounds like it's going to be interesting as well. The gentleman is recognized.
Thank you very much, Mr. Speaker. Members, first and foremost, I'd like to highlight two things. This bill was critical to the Department of Corrections, the Georgia Sheriff's Association, and others. But I want to say thank you to Chairman Crow and the Public Safety Committee for doing a combined meeting with TII. I think it helped to perfect the bill. In addition, after 3 hearings with TII, we were able to get unanimous passage through the bill. So I want to thank everyone who participated in this. The bill basically has 2 key parts. This is around unmanned aircraft systems. We have a real challenge with places of incarceration, which are basically prisons and jails. We are having operators effectively go over the places of incarceration. They are videoing, they are landing, they are basically delivering contraband, etc. This is happening hundreds of times a year, not just a few times a year. So this bill effectively puts them into Title 42, into the criminal statutes, and basically we hope be a very big deterrent to having these unmanned aircraft go over places of incarceration. The second part of the bill does a quick refinement to Section 614, which we did last year around unmanned aircraft, and we did a couple of refinements based on what we learned from the past year. Mr. Speaker, that is the bill in its totality, except I'd like to add several counties, several cities, including the city of Atlanta, have voiced a very, very big support for this bill. So thank you, sir.
Gentleman has no questions.
Thank you very much. I yield the well and ask for your favorable consideration.
Gentleman has yielded well. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to adopting the committee substitute? Hearing none, the committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? All members voted? If so, Mr. Clerk will lock the machine. On the passage of House Bill 1230, the yeas are 166, the nays are 2. This bill, having received a requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption of House Bill 1045, 1045?
House Bill 1045 by Representative Herring of the 145th and others to be entitled an act to amend Part 3 of Article 16 to Chapter 2 of Title 20 of the Official Code of Georgia Annotated relating to student health and elementary and secondary education so as to enact the You Are Not Alone Awareness Act. This bill having referred to the Committee on Education, that committee recommends that this bill do pass by committee substitute.
Representative Tangi Herring is recognized to present this bill. House Bill 1045. The lady's recognized.
After this long day, I was in a rush to get up here. Thank you, Mr. Speaker, members of this House. I rise today not only as a legislator, but as a mother and someone who spent 28 years in a classroom here in the state of Georgia teaching our children. Soon we will vote, but before we do, I ask you to picture a child. Picture a 17-year-old carrying the weight of the world on his shoulders and not being able to describe it. Picture the quiet warning signs we sometimes miss. Long sleeves in August, a once talkative student who grows silent, grades that begin to slip, sudden anger and withdrawal. Picture the child who experiments with drugs, pulls at his or her hair, and harms their own skin. These are not acts of rebellion. These are signals. They are in pain, and it's made visible. They are cries for help. As an educator, I saw those signs. I have known children who struggled silently, and I have known parents who carried the heartbreak of realizing too late how deeply their child is hurting. Too often, families are left wishing they had one more opportunity, one more moment, one more connection that might have opened the door for help. This issue is deeply personal to me. I have seen the grief in the eyes of a dear friend who lost their beloved son to suicide. A young life filled with hope and promise, yet carrying pain and suffering that no one fully saw. Too often, suffering happens in silence. The silence can steal hope before help ever arrives. That is why this legislation matters. This is one simple act that could potentially save a struggling student, but also save a family member, a friend, or a parent from unimaginable loss. And this is not hypothetical. In Bibb County alone, we recently lost a 14-year-old child to suicide. Just last month, a 12-year-old in Byron took her own life due to bullying. A family is grieving, a school community is grieving, and we are left asking, what more could we have done? Today, we have an opportunity to do something simple, practical, and compassionate. House Bill 1045, the You Are Not Alone Awareness Act, requires the public schools that are issuing student ID badges, grades 6 through 12, include 988, the crisis hotline, and the words, "You are not alone." That's all. We don't need to create any new bureaucracy. We are not adding curriculum mandates. We are not imposing a financial burden. We are placing a lifeline where every student can see it quietly, consistently, and without stigma. Some worry that talking about suicide introduces harmful ideas. Research shows the opposite. Making help visible does not increase risk. Silence does. Isolation does. Stigma does. What saves lives is connection and immediate access to support. By placing this information on every badge, no child is singled out. No student has to raise their hand or explain their pain. Every child carries the same message every day. Help is available, and they are not alone. Self-harm hides in plain sight. The warning signs are subtle. And in moments of crisis, clarity matters. Seconds matters. Access matters. If one student in a difficult moment turns over that badge and chooses to call 988 instead of harming themselves, then this legislation has done exactly what we are sent here to do: protect the people of Georgia, especially our children. We cannot prevent every tragedy, but we can remove barriers. We can offer hope. We can make it easier for a child to reach out and find a family member to offer help before it's too late. Members, years from now, none of us will ever remember the speech we gave or every vote that we cast. But somewhere in Georgia, a child may still be alive because we chose to act today. Let this be the moment when this bill, this House bill, decided that silence would not win, that hope would be visible, and that every child would carry a reminder that help is right there in reach. Let us pass this bill and send a clear message to Georgia's children. You are seen, you are valued, and you are not alone. I respectfully ask this House for your favorable vote. And Mr. Speaker, I'll stand for questions.
Thank you for your presentation. Representative Dawson, to your left, is recognized for a question.
Thank you, Speaker. Does the gentle lady yield?
I do, to my friend.
Is it not true that this type of public health, mental health awareness legislation and policy strikes at the very core of public health policy in Georgia?
Yes, it does.
Does the gentle lady yield one more time?
I do.
Is it not true that this is your first bill?
Yes, it is.
Okay, well done.
Thank you.
Lady, yield for another question. Representative Rice, to your left. Representative Carmen, wait, yes, your extreme left.
Thank you, Mr. Speaker. Does the gentle lady yield?
I do.
So Representative Dawson took one of my questions on this being your first bill, but is it not true that your first piece of legislation will never know on this side of earth how many people that it saved and lives it changed?
The gentle lady knows what she speaks.
Representative Franklin, to your left as well. Representative Lehman Franklin, extreme left.
Right here.
Representative Herring, to your extreme left.
Does the gentle lady yield?
I do.
I'm just curious. When I was in public school, we didn't have badges at all. Do you know how many schools in Georgia have to have these badges or have badges?
The majority of our schools in the state of Georgia do have student badges. They have their student IDs. With this, you will only put the sticker, or the school system can be able to decide how they want to implement the badges, the 988 Act on the badges. So all schools right now, they do have badges. Most public schools do.
So does January continue to yield?
Sure.
So the ones that, you're saying that pretty much all of them have it. The ones that do have to have this sticker on it. The ones that don't are not required to do the badges. Is that what you're saying?
Most public schools in the state of Georgia, they do have student badges. So the ones that do have the badges, they do have to put the sticker on them.
Okay, thank you.
You're welcome.
Representative Bell is recognized for a question. To your right. To your right. Yes, ma'am.
Parliamentary inquiry.
No, you're recognized for a question.
Does the gentleman lady
Yes.
yield? I'm new at this. I'm sorry.
The gentle lady yields.
Isn't it true that we're all someone's mental health patients?
I'm sorry?
Isn't it true that we all could be someone's mental health patients?
I don't. That depends.
Is it
Maybe you
not
are.
true that we all could be someone's mental health patient?
If that is your opinion, yes, we could all be mental health patients.
Isn't it further true if we had legislation like this when we were a lot younger, this august body would be so much better off doing the work of Georgians?
Yes.
Thank you. Good job.
Thank you.
Lady, you for one more question. Representative Townsend, right down the center aisle on the right, is recognized for a question. This
Thank
will
you,
be your
Mr.
last one.
Speaker. Does the representative yield?
I do. I got to get used to this.
Is it not true that this will save lives?
Yes, it will.
Can I ask a second question?
Yes.
Is it not true that any school I know of in the state of Georgia have lunch cards? They could put the stickers on the back or the printing on the back if they wish to. So schools do have the cards.
Yes.
Thank you.
Lady has no further questions. May I ask her a question?
Sure.
Doesn't your legislation, which we're very grateful for, further the ongoing efforts of this House to deal with mental health issues in our state?
Yes, it does, Mr. Speaker.
Thank you for the bill.
Thank you. I yield the will.
Ladies yielded the well. Thank you for the bill. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to adopting the committee's substitute? Hearing none, the committee's substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? For what purposes Representative Taylor rise? Representative Taylor, did you have an inquiry? Evidently not. Have all members now voted? If so, Mr. Clerk will lock the machine. On the passage of House Bill 1045, the yeas are 168, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Congratulations. Great bill. Representative Olalier, you didn't have to hold on to the fish very long, did you? You didn't hold on to the fish very long, did you, before you passed it on? Congratulations, Representative Herring. Proud of you and proud for you. Mr. Clerk, will you read the caption to House Bill 664?
House Bill 664 by Representative Silcox of the 53rd and others to be entitled an act to amend Article 6 of Chapter 3, Title 44 of the official code of Georgia annotated relating to property owners associations so as to provide for property owners associations to submit to said article after the creation of such associations. This bill having referred to the Committee on Judiciary, that committee recommends that this bill do pass by committee substitute.
Chair Lady Silcox is recognized to present House Bill 664.
Thank you so much, Mr. Speaker. I bring to you this evening House Bill 664, and this comes to us from my hometown of Sandy Springs. Hunt Cliff subdivision is one of the largest and oldest subdivisions in my district, and it was actually started in 1966. And so it has covenants and restrictions for its homeowners association there, but they are very old. And because they were so old, they never had a provision within those covenants to be able to amend them at any time. And in 1994, this body passed what became known as the Georgia Property Owners Association Act of 1994 that would allow subdivisions that had a provision for amendment in them to opt into that act so that they could then amend their covenants. But unfortunately, because Hunt Cliff was so old, it is a product of what's known as frozen covenants, and so it is actually a hole in our law. And this would actually repair that hole and say that with a vote of 75% or more of the homeowners in that homeowners association, that they could opt into the 1994 Act so that they would be able to amend their covenants, and then they could propose amendments to those covenants and pass those amendments, again, with another 75% or more vote by the homeowners association. This does not change the structure of any homeowners association. It does not change the governance of a homeowners association anyway. This is really just repairing a hole in our law to allow frozen covenant situations to opt in to the 1994 Georgia Property Owners Association Act. So with that, I'd be happy to take any questions.
Lady has a couple of questions. Representative Wilkerson, and back in your on your left in the back. If members will sit in front of him so we can see Representative Wilkerson, Representative Jackson.
Thank you, Mr. Speaker. Does the gentlelady yield?
I sure do.
So by opting into this Property Owners Association, is it not more restrictive than just being an HOA? Because I know being part of it has benefits, but it also has more restrictions to it. Are you familiar with those?
No, it does not. It doesn't restrict it in any way. It just allows them to be able to amend their covenants. Because as it is right now, they can't change their covenants at all, even with 100% vote of the homeowners. But it doesn't restrict them in any way.
Well, does the gentlelady have one more question?
Yes, sir.
My understanding, just dealing with HOAs, is we know a lot of us have put forth bills or supported bills that would tighten up the restrictions. And one of the things that is recommended to HOAs is to put it themselves into the Property Owners Association Act because it does give them more enforcement power. And my only concern would be that HOAs, which are already a problem, would just, more people would face the same problems we do.
This just allows them to be able to amend their covenants, which I think, given the current climate, is a very difficult, it's an uphill battle because they would have to have 75% or more of their homeowners vote to actually amend the covenants. This just would give them the power to be able to do that.
Lady yield, Representative Doreen Carter to your left, extreme left, back over here. Yes,
Thank
ma'am.
you. This is gentlelady yield.
Yes, I do.
So my question is, reducing this to 75%, will that address the issue where some HOAs can't find the owners and a lot of them can't even get to 50%? So how will we address that? Because the issues we're getting from subdivisions is they cannot change their covenants. And I appreciate what you're bringing,
No, of course.
but will 75% really help those communities where we have these owners, especially in older subdivisions, to your point, and now they're renting them out and we can't find the owners?
We debated this very point and actually suggested in committee that it be a lower threshold. But the people who testified on the bill, the attorney who testified, said that 75% is kind of a standard in the industry now, and that if we lowered it any more, that it could bring legal action against the association because there are other comparable subdivisions in that area that have 75%. So, but it's an excellent question.
Representative Sandra Scott to your right is recognized for a question.
That's the gentlelady yield.
Yes, ma'am.
Okay, many Georgia neighborhoods are now seeing increased corporate and investor ownership. If those investors can reach the 75% voting threshold, what prevents them from changing HOA rules in ways that increase fees, fines, and liens that disproportionately burden seniors, working families, and first-time homeowners trying to keep their homes?
Sure. I appreciate your question, but again, this really has nothing to do with who owns property in the subdivision or is going to own property in the subdivision. This has to do with the will of the people living there being able to amend their covenants.
Does it relate further you?
Yes.
Okay, so is it not true that by lowering the voting threshold to 75%, this bill could allow investors who own multiple properties in a neighborhood to control the HOA votes and adopt the rules that increase fees, fines, and liens, placing the greatest financial pressure on the homeowners who actually live there?
I appreciate your question, but I can't really speculate what might happen in the future. I just know that the homeowners in Hunt Cliff subdivision brought me this, and they want to be able to amend their covenants, and it doesn't have anything to do with corporate ownership or changing or imposing more fines on the homeowners. It just has to do with the ability of the will of those people in that area to be able to amend their covenants.
Okay, thank you. Lady, you for one more, Representative Rice to your left.
Yes.
Extreme left, your other left, that one.
Oh, there we go.
Thank you, Mr. Speaker. Does the gentlelady yield?
I do.
Does House Bill 664 support property values by making community rules easier to update and understand fairly?
I really appreciate that question, Representative. It does, and I think it helps to protect home values for sure. Thank you so much.
You have one more question, whether you would, it's up to you whether you yield or not. Representative Davis, she waves.
Okay.
You have no further questions.
Thank you so much. I yield the well.
Ladies yielded well. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to agreeing to the committee substitute? Hearing none, the committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All those in favor will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? All members voted. If so, Mr. Clerk will lock the machine. On the passage of House Bill 664, the yeas are 121, the nays are 44. This bill having received the requisite constitutional majority is therefore passed. Members, we're going to go a little bit longer because of the time we are in the session. We're going to take up just a couple more bills, and then we'll call it a day and get started again tomorrow. Mr. Clerk, will you read the caption to House Bill 1290.
House Bill 1290 by Representative Hilton of the 48th and others to be entitled an act to amend Article 8 of Chapter 5 of Title 16 of the Official Code of Georgia annotated relating the protection of elder persons so as to revise the definition of sexual abuse. This bill having referred to the Committee on Judiciary and Non-Civil, that committee recommends that this bill do pass.
Chairman Hilton is recognized to speak to House Bill 1290.
Thank you, Mr. Speaker. Like many of you, I am passionate about protecting our state's most vulnerable citizens, along with keeping our communities safe. House Bill 1290 targets the sexual exploitation of an elder person, disabled adult, or resident in a long-term care facility by making three important changes. It changes the standard from coercion to consent, the rationale there being someone who is comatose or a nonverbal person is unable to be coerced. The second change is it removes the requirement that a person be a caregiver or an authority position because oftentimes, unfortunately, we see a neighbor or family member commit the abuse. And then lastly, this bill adds sexual abuse or exploitation of an elder to the sex offender registry commensurate with the sexual exploitation of children. I ask your favorable consideration as this body fights to protect those who are most vulnerable and need it the most amongst us. And so with that, Mr. Speaker, I will yield for any questions or parliamentary inquiries. They got it.
Gentleman has no questions.
Thank you, Mr. Speaker. I yield the well.
Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. You did yield the well, didn't you? Yeah, I thought you did. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. Mr. Clerk will unlock the machine. Have all members voted? Not quite. Have all members now voted? If so, Mr. Clerk will lock the machine. On the passage of House Bill 1290, the yeas are 167, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption of House Bill 1396, 1396?
House Bill 1396 by Representative Abstration of the 104th to be entitled an act to amend Article 1 of Chapter 8 of Title 50 of the Official Code of Georgia annotated relating to general provisions relative to the Department of Community Affairs so as to require certain privately funded organizations that operate a shelter or provide outreach services to homeless individuals within 1,000 feet of schools, public parks, playgrounds, or certain child care facilities to participate in the Georgia Homeless Management Information System. This bill having referred to the Committee on Governmental Affairs. That committee recommends that this bill do pass.
The gentleman from Mulberry is recognized, Leader Abstration, to present House Bill 1396. The gentleman is recognized.
Thank you, Mr. Speaker. Ladies and gentlemen, I bring to you House Bill 1396. As you may recall, 2 years ago, I really began work by passing what at the time was HB 1410, working to address the issue of unsheltered homelessness in our state, putting in place a separate aspect of the Georgia Homelessness Trust Fund that would provide for measures allowing unsheltered homeless to be on a track to be self-sustaining, to have a means by which, similar to the accountability court structure, to be in job training, alcohol and drug treatment, and with state dollars that are provided, that there's actually accountability measures to ensure that these individuals are in a position to get better. And so I was very proud of that measure, and I view this bill as a next step. Right now we have significant funding, state and federal funding, to address unsheltered homelessness in our state. And while I think many individuals who are involved in this, whether well-meaning and receiving government assistance for the efforts or privately funded organizations, there must be a means by which to track the services that are being provided to make sure we have some metrics as to the quality of care that's being received. So through DCA, there is the HMIS, a Homelessness Management Information System. This is a database as to the services that are provided. Entities receiving government funds must participate in this. But what this bill would do is require in Atlanta, if there are private entities within the proximity to public parks and the like, that if these services are being provided by private entities, that they too would participate in the HMIS framework, which I think will provide needed data to make sure that we're best serving unhoused, unsheltered homeless individuals in our state. And Mr. Speaker, I'd be happy to yield for any questions, and I'd ask for the body's favorable consideration.
The gentleman has several questions he would address. Representative Sanchez, to your right, in the back a little bit.
Yes.
The gentleman's recognized.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
Thank you. I know we talked about this in committee, but just to clarify, this only applies to Fulton County, correct?
I said that in committee. I believe it's only the Atlanta municipality.
The city of Atlanta.
Yes, sir.
Got it. Do you further yield?
Yes, sir.
Is there a reason we're only doing this for the city of Atlanta, not statewide?
So what an initial draft of the bill prior to introduction was would more broadly apply. In my view, focusing this on the city of Atlanta, where we have more of an issue and making sure we don't capture well-intended charities in other parts of the state that may not be familiar with the HMIS system is why I drew this very narrowly. And just to identify, that's lines 56 to 60 where it specifies it's just for Atlanta.
Thank you.
Yes, sir. Thank you.
Representative Park Cannon is recognized for a question.
Thank you, Mr. Speaker. Do you yield?
Yes, ma'am.
What is the process to participate as an authorizing agency?
Which line or aspect of the bill are you talking about?
So am I correct that this bill requires that an entity that operates services must now participate as an authorizing agency of GHMI?
So as I understand the process, currently the HMIS database administered through DCA, Department of Community Affairs, is available, and participants by law are any entity receiving government funds to provide services for homeless individuals. And this would include, within this limited area, those who are not receiving government funds to also participate. And so by that, that would be a captured organization.
Mm-hmm. Thank you. Do you further yield?
Yes, ma'am.
So what is the process to participate? Is it simply they receive this funding and they check a box to say, I participate? Or is there a course they have to go through? What is the process to participate?
I see. As I understand it, what they would do is have a means by which to register for the system through DCA. So as they're providing, let's just say it's a charity that decides that they want to provide assistance, that they would, through DCA, be given access to make entries into the HMIS system, and then for whatever services they're providing, they would enter that into the system when they provide those services.
Okay. I am still unclear, but thank you. Do you further yield?
Yes, ma'am. Yes, ma'am. Go ahead.
So how many privately funded entities currently participate, and how many publicly funded entities currently participate? What is the, what are we solving here?
Right. So to answer the first part of your question, we do not know how many, well, to answer broadly here, we do not know how many private charities that are not receiving government funds are providing these services. That's really that's the reason that we need the bill. And as far as privately funded charities that are participating in HMIS, I do not know the number, but I don't believe there's very many of them that are actually participating. There again, that's why we need the bill. By law, any publicly funded charity must be providing the data in HMIS currently.
Thank you. Do you yield for one final question?
One final question.
As the chair of the Fulton County delegation, have you spoken with Fulton County External Affairs or the City of Atlanta local leadership about this legislation, and what did they say?
So I have not personally spoken to them. It is my understanding that there has been communication with the City of Atlanta as well as legislators that represent Atlanta about this legislation. And I have not heard of any opposition to the bill since it was introduced. It passed unanimously in committee. Mr. Speaker, I'll yield for one final question if there are any.
Representative Willis is recognized for a question. To your right.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
Is it not true that homelessness or issues around the unhoused is a statewide problem and not just a local one?
Absolutely.
Does the gentleman further yield?
Yes.
In the absence of collaborating with or sitting with members of the Atlanta delegation, the Fulton County delegation, the City of Atlanta, or Fulton County, how do we know this is the right solution for the city that we live in? And do you live in the City of Atlanta? Thank you.
So to the gentlelady's question, I would just respond by saying this General Assembly has appropriated significant funds, Georgia taxpayer funds, to address the issue of unsheltered homelessness, which is predominantly an issue in Atlanta. It is a statewide issue, but it is an issue that we observe here coming to the state capitol. I'm not a resident of the city of Atlanta. I'm a resident of Mulberry. But I am aware of the issues. Certainly when I come here, my heart goes out to individuals who are unsheltered and homeless. And I believe that taxpayer dollars that are spent, be it state or federal dollars, need to be spent most effectively. And the way to determine that is by tracking it in a data system. Mr. Speaker, I'd ask for the body's favorable consideration, and I'll yield the well.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. Those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? All members voted. If so, Mr. Clerk will lock the machine. On the passage of House Bill 1396, the yeas are 105, the nays are 58. This bill having received a requisite constitutional majority is therefore passed. For what purposes Representative Jason Ridley rise?
Make a motion.
State your motion.
I request that House Bill 1324 be recommitted back to rules, please.
Mr. Clerk, will you read the caption?
House Bill 1324 by Representative Ridley of the 6th and others to be titled an act to amend Article 4, Chapter 11 of Title 16 of the Official Code of Georgia annotated relating to dangerous instrumentalities and practices.
On the gentleman's motion that House Bill 1324 be recommitted to Rules Committee, is there objection? Hearing none, is so ordered. For what purpose Representative Stevens rise?
To make a motion.
State your motion, sir.
I move the House Bill 574 go back to the Rules Committee.
Mr. Clerk, will you read the caption?
House Bill 574 by Representative Stevens, the 164th to be entitled an act to amend Code Section 3492 of the Official Code of Georgia annotated relating to applicability of workers' compensation to employers and employees generally.
On the gentleman's motion that House Bill 574 be recommitted to the Rules Committee, is there objection? Hearing none, is so ordered. Here's the one you've been looking for, and y'all know which one that is. I won't explain it. Mr. Clerk, will you read the caption of House Bill 1076?
House Bill 1076 by Representative Earhart of the 36th and others to be entitled an act to amend Article 2 of Chapter 10 of Title 16 of the Official Code of Georgia annotated relating to obstruction of public administration and related offenses so as to create the felony offense of obstruction of a law enforcement officer with a motor vehicle. This bill having referred to the Committee on Judiciary and Non-Civil, that committee recommends that this bill do pass.
So we do have some folks signed up to speak on this bill, and we have a minority report. So it's getting a little bit late, but we're going to finish up with this one. So I'm going to recognize Representative Jeannie Earhart to speak to House Bill 1076. Ladies recognized.
Thank you, Mr. Speaker. Members, I present for your consideration HB 1076, which is a public safety bill with the purpose of protecting the lives and well-beings of our law enforcement officers, as well as members of the general public. This bill will make it a felony to use a motor vehicle to knowingly obstruct, hinder, block, or otherwise interfere with law enforcement officers in the discharge of their official duties. Currently, this offense is prosecuted under a more general obstruction law as a misdemeanor, and the obstruction code currently makes no distinction between general Non-dangerous obstruction, examples would be lying to police officers, tampering with evidence, fleeing on foot, and obstructing with a 4,000-pound motor vehicle. The reason for carving out obstruction with a motor vehicle from the General Obstruction Code is because of the dramatically increased risk of danger and personal injury associated with using a motor vehicle to disrupt an active police operation. If this vehicle also happens to be driven by an individual with the intent to obstruct or impede that operation, the outcome could be deadly for both our law enforcement officers and the people engaging in the obstruction. It is dangerous conduct for all involved and should be taken seriously. Georgia is not alone in this concern. From 2020 to 2025, there has been a 230% increase in state-level bills filed to combat vehicle-related crimes like this. Why is that? Let's be very clear about the danger. Over the past 20 years, all types of motor vehicle-related incidents, on average, have been either the number 1 or number 2 leading cause of death and injury to law enforcement officers, second only to gunfire. From 2023 to 2024, deaths to on-duty law enforcement officers as the result of all motor vehicle incidents rose by 48%. The danger is real. A motor vehicle in the hands of an ill-intentioned person is a lethal weapon. That is likely why 24 other states have classified this dangerous conduct as a felony. The goal of HB 1076 is to provide an enhanced deterrent to obstruction with a motor vehicle by increasing the penalty from a misdemeanor to a felony. It is highly likely that many individuals who engage in this kind of obstruction purposely may not realize or anticipate that their actions could actually end in injury or death to themselves or law enforcement officers. Yet these scenarios escalate quickly, and the risk is high. We need to deter this crime before injury or death occurs. As with many criminal offenses of this nature, intent will need to be proven and will be a prerequisite for conviction of this crime. Members, classifying this particular offense as a felony is necessary because of the extremely high risk of potential danger. Legislatures across the country, and like ours, often treat nonviolent weapons-related conduct as inherently serious because of the risk and the possibility of rapid escalation. This bill is supported and endorsed by the Georgia Sheriff's Association and the Georgia Chiefs of Police. Mr. Speaker, that is the bill, and I'll yield for any questions.
You have a couple of, lady will yield to Whip Park, right in front of you there has a question. The gentleman's recognized.
Thank you, Mr. Speaker. Does the gentlelady yield?
I do.
Why are we creating a new felony when OCGA 1610-2024 already covers hindering an officer with violence or threats?
Well, if you're talking about the felony offense of obstruction, there is a requirement for violence in that particular offense. I am familiar with that code. This is punishing the conduct. Should someone use a motor vehicle to interfere with a police operation and injure or harm or strike a police officer, that takes it to a different level. Then you're talking about aggravated assault. So that is the difference.
Does the gentlelady further yield?
I do.
So is it not true that this is ultimately, given the redundant nature of your proposal, really something that is just a political response to an American citizen, Renee Good, who was shot and murdered by law enforcement, and that all this bill really does is just, again, is yet another political ploy? Is that not true?
Oh, absolutely not true. On the contrary, this bill does not deal with violent actions towards police officers, to be very clear, and the code that you referenced does. This deals with the dangerous conduct involving a motor vehicle and law enforcement officers. In terms of your reference to recent events, I would argue that no, we have seen a dramatic escalation in motor vehicle-related instances with police officers since 2020, far before, long before the incident that you referenced.
Does the gentlelady yield for a final question?
Yes.
So your bill would make it a felony for there to be a parked car that's not moving? Can you help me explain how that constitutes a threat?
Absolutely,
to a police
absolutely. I'm
officer's
happy
life?
to do. Yes, I'm happy to do that. To be clear, very, very clear about parked vehicles, using a vehicle to block officers, whether blocking them in or blocking them out, is not a benign action. It is not an action without potentially serious consequences for a host of reasons. Law enforcement has shared this information with me. Prosecutors and others in the field have shared this information with me. Number one, using a blocked car to impede a police operation, you prevent emergency response for anyone who might be in need of help. Number two, you cause a situation to escalate, not just between obstructors and law enforcement officers, but between obstructors and bystanders even. Number three, as any police officer would tell you if you asked them, a stationary vehicle used to purposely interfere with an active operation distracts those officers at a time when they should be focused on the operation at hand and the safety of all involved. And that distraction enhances danger.
Thank you.
Does the lady want to yield for some more questions?
Yes, I'll yield for another one or two.
Representative Miller, right in the center aisle, is recognized for a question.
Thank you, Mr. Speaker. Does the gentlelady yield?
Yes.
Just to, I really want to understand what we're trying to accomplish here, and I'm intrigued a little bit by the question my colleague, the Minority Whip, asked you about parked vehicles. Okay. So can you give me an example for how a vehicle that is stationary, in other words, was not driven to a place and then put there, could be obstruction or felonious under your bill?
Okay, well, I would argue that someone did have to drive that vehicle there to begin with, right? And then park it in a manner that is impeding a police operation. So for all of the 3 or 4 reasons that I just gave as to why that is can impede a police operation and create a dangerous situation, I feel like I explained that, but please let me know if I can further elaborate.
Yeah, you can further elaborate. So what is the intent element? I guess what I'm trying to figure out is, can a car merely be parked and then become obstructionist without any conduct by the person driving it?
Thank you for the question, and it does make sense. I would explain though to you that you're now talking about, remember, intent is a prerequisite for prosecution of this law, right? So that person would have to be deliberately intending to obstruct that operation. It would not include someone that just parked their car there and then later are you insinuating that maybe later a police operation just crops up around the car? The person would have to have intentionally driven the car there and parked it in a way to impede that police operation.
Understood. Thank you.
Mr. Speaker, I'll yield for one more question.
Representative Roman, right at the center aisle on your left, is recognized.
Thank you, Mr. Speaker. Does the gentlelady yield?
Yes.
So there was a little bit back and forth earlier about why we are making this a new felony, and you mentioned that those were violent felonies. Is your argument that this is now a felony for peaceful or nonviolent action?
No, it's a felony for dangerous conduct with using a motor vehicle that impedes or interferes with the police operation.
But
we have many felonies on the books that are nonviolent. There are weapons possessions charges that are nonviolent. They don't actually involve firing a gun or harming anyone. Nonetheless, this body, this state, recognizes that those are inherently dangerous conduct, and therefore there are felonies on the book for a host of nonviolent offenses.
Got it. So it's nonviolent. Thank you.
Mr. Speaker, that's all I have. That is the bill in a nutshell. I will yield the whale.
Ladies, yielded the whale. We do have speakers signed up. They're opposed to the bill. We have, let's see, looks like about 4, and then we do have a minority report. Representative Sanchez, you're recognized. Speak to the bill. This gentleman's recognized.
Thank you, Mr. Speaker. I rise today on the 250th anniversary of the Declaration of Independence. And what we're doing here is attacking a fundamental right that dates back to the core of the founding of this nation. The right to protest is a cornerstone of American democracy. And just like my colleague already mentioned, what was the impetus for this bill? Was it the murder of Renee Good? Because under this legislation, you would have slapped a felony charge and a $100,000 fine onto her lifeless body if this had happened in Georgia. Is that what justice looks like to you? Are we defending the murderer of Renee Good? We need to stop legislating against people just because you do not agree with them. Because that's exactly what this bill is doing. I'm sorry if protesting for civil rights and civil liberty annoys you, but that is the point of protest. Protests are supposed to be disruptive. This nation would not exist without protest and disruption. Anyone want to call back to the Boston Tea Party? Or the Boston Massacre, where people protesting against the British government were killed. By the way, they were tossing things towards those British soldiers. So you could argue that there's a lot of parallels from the Boston Massacre to today's protest against ICE. And now that we have people, American citizens, murdered for simply expressing their right to free speech, like Renee Good, Alex Preddy, Keith Porter, and many more. We are tarnishing the legacy of our founding fathers and the legacy of this country by undermining such a core fundamental right with this legislation. It seems to make sense the Republican Party is red because this legislation really makes you all look like redcoats. I hope this body will consider, once again on the 250th anniversary of the Declaration of Independence, to not undermine one of our most fundamental rights. So I hope that you vote no on House Bill 1076. Thank you, Mr. Speaker. I yield the well.
Gentlemen, yield the well. Representative Holly. Gentleman's recognized.
Thank you, Mr. Speaker. My colleagues, I rise today to both ask you to vote your conscience and therefore vote against this measure. House Bill 1076 seeks to create a redundant criminal offense for obstructing a law enforcement officer using a motor vehicle. And while everyone agrees that violence against law enforcement is unacceptable, that officers must be able to do their jobs safely, this bill is the wrong tool. It unnecessarily, given the existing law, is dangerously vague and it opens the door to discriminatory enforcement and excessive punishment, especially against minorities and people exercising their constitutional rights. Civil liberties and civil rights organizations in Georgia have consistently warned that these new criminal offenses and sentence enhancements in the name of order and public safety often end up eroding our constitutional protections and deepening racial disparities that already exist in the criminal and justice system. We must challenge ineffective, costly pretrial and sentencing practices and opposing bills that expand criminal liability without clear need or safeguards. Let us review the robust set of laws that Georgia currently punishes for dangerous conduct involving a vehicle and a police officer. Our respected members of even the Georgia State Police know this legislature has already granted them the ability to charge any suspect with the following crimes: aggravated assault on a peace officer, fleeing an attempt to elude, reckless driving and related traffic crimes, and existing obstruction statuses. Think on this. If someone deliberately uses a motor vehicle to harm or threaten an officer, prosecutors can already charge felony obstruction of an officer, as Section B increases the offense from a misdemeanor to a felony. Now, how might I know? I say it time and time again, but it's just good to put it in perspective. You can walk 2 blocks north where I wrote the criminal arrest warrants for 13 metropolitan counties and including officers of the Georgia Bureau of Investigators, processing their criminal arrest warrants, and I signed my name as a warrant officer on obstruction of an officer felony warrants. Almost tens of thousands of them that came through me over those 5 or 6 years. Creating a new felony category specifically for obstructing using a motor vehicle, it invites duplication, confusion, and governmental overreach. Justice organizations have repeatedly emphasized that Georgia does not suffer from a shortage of criminal statutes. Instead, it suffers from one of the highest per capita correctional rates in the entire nation. If we really want to stop crime and support responsible law enforcement, we should be focused on minimizing these manufactured scenarios that seem made for nightly news broadcasts, but they only rebrand laws that are already on the books, that have already been applied to suspects over the years. HB 1076 frames itself as targeting obstruction, but here's the key question. What exactly counts as obstruction? Without extremely precise statutory language, this bill risks turning routine or ambiguous situations into felonies. How, you might ask? Because as is written, persons charged with this offense, they need not show any intent to harm officers, no intent to harm the public, or even harming themselves. The mere presence of their motor vehicle in the lane or near a lane or in any place where an officer is pursuing a suspect automatically suggests that the driver should have known there was an active police matter happening in that moment if they failed to move their vehicle. Yes, you've heard that correctly. The bill's sponsor wants you to believe that any person, not just a protester, not some miscreant, not a spectator, but a grandmother who can't hurry up and get out of the way, or ordinarily law-abiding citizens whose Camrys or Buicks or any other regular vehicle can't move fast enough or may be momentarily inoperable at the time a pursuit is taking place, deserves to be charged with an automatic felony, punishable by up to $100,000 or even 5 years in jail. So let's think about who those persons might be. A driver who hesitates, panics, or misunderstands an officer's hand signals. Someone slowly maneuvering around a police vehicle at a traffic stop or a protest, believing that the road is partially open. Is it a protester, or is it a legal observer in a car near a demonstration who was accused of blocking an officer's path, even if they are simply just sitting in traffic? The felon this law seeks to stop is you. The U.S. Supreme Court has consistently warned against and has invalidated criminal laws under the void for vagueness doctrine, which is rooted in the Due Process Clause of the 5th and 14th Amendments. That's why the American Civil Liberties Union of Georgia and the NAACP have long warned that vague criminal laws allow law enforcement to police the person, not the conduct, giving officers very wide latitude to interpret ordinary or protected activity as quote-unquote criminal. A law that can turn a confusing or emotionally charged traffic encounter into a serious felony is fundamentally dangerous. It gives officers a powerful tool that can be used, not to say that it will, but it can be used to threaten, to coerce, or to retaliate in situations that should be resolved with de-escalation, with clear instructions, and at worst, an existing misdemeanor or traffic charges. When a driver is confronted with a chaotic environment, think about this for yourselves. This is real. Sirens, smoke, large crowds, extreme weather. And then approached by an officer, several factors can lead to a total immobility. The brain receives more sensory input than it can process. This leads to a tonic immobility, where the body simply stops responding to external commands. If a threat is perceived as inescapable, your brain may trigger a freeze to avoid detection because it can't decide on a course of action. Now, I know this personally to be true. I remember 5 years ago when I was on I-75 going north, and literally, as an officer was there trying to get a mother to unload the children out of her Chevy Suburban, and I saw her tense and freak out, it caused me to pull my car over to the side. And one by one, as I pulled the children from the passenger seat of the vehicle, I saw that woman stressed and to the point that she was clutching her head. In that moment, I thought it wise to judge her. I said, how can this woman sit here on the highway as her car is burning? Literally, flames are coming from the hood. Officers are pointing her to move, and she can't. And she's stressed out. And even though we were able to successfully get those children into my car and other cars that were there and to drive those vehicles out of the harm's way, I imagine for myself what she must have been feeling in that moment. Was she trying to break the law when the officer asked her to respond? Could she even factor the harm that was created at the thought that her children could have been scorched if she didn't respond correctly? But still, she found herself in that moment clutching her head. And I realized over the time that maybe it was not right for me to judge her, that I too could find myself in a situation where physically or emotional shock might cause some sort of disassociation from reality. And that makes it hard for any driver, almost placing them in a catatonic situation, unable to respond quickly. So, I think we were very clear here. And really, this message is not for any of us in this room. This is for you at home who are watching. When this bill passes out of here, I want you to know that for many who are watching, particularly our seniors, those who are members of AARP, who without your support, many of us wouldn't be seated in this chamber. You who are law-abiding, who don't find yourself in situations where you're trying to break the law, if in our times, where because of the mere fact that your car is sitting idly, because you haven't been able to respond quickly, you will now be placing yourself in the same position that others who do not necessarily have a desire to obey the law will find themselves when they are unable to move their car out of harm's way at the direct order of an officer. And that is the reason why this bill does not exist in law, because the culpability of the person who will be arrested, it doesn't need for them to be showing that they intentionally desire to have that car to stop an officer. It just says that they have to have known about it, that there's some type of knowledge. And for anyone who has never been in a situation where you are literally in a parade or amidst a crowd, or even where you're at a sports game and there's large crowds in the street, or if you find yourself incapable of moving your car because there's a Bearcat, a very large decommissioned Army military vehicle that sometimes police departments have, if you're unable to respond quickly, then yes, you too might be able to beat your charges, but this will at least allow for a law enforcement officer to apply a high felony to you, of which, again, is you can have a fine on you for up to $100,000. Let us respect the law that is currently on our books. Section B of 16-10-21. Actually, I apologize. The hour is late and my mind is not on a particular code, but I do know that Section B of aggravated assault on an officer actually can be applied in situations where the suspect is arguably trying to actually hurt the officer. We don't need this bill, and we don't need it because we already have laws on the books to be able to protect people. So please, I ask for you to do the right thing. This is simply not about targeting suspects. We have to make sure that those who are law-abiding but cannot respond quickly are not hit with a felony charge. That's why I ask you all to please vote no on this. And I ask the public to please show some mercy for those who do not intend to do the harm they do to you. I yield the will.
Gentleman is yielded the well. Representative Derek Jackson. Gentleman is recognized to speak to House Bill 1076.
Thank you, Mr. Speaker. Ladies and gentlemen, I know the hour is late and you're probably hungry. But listen, House Bill 1076. What's broken that House Bill 1076 is trying to fix? My remarks are going to be brief, so here we are. Not only House Bill 1076 will create penalties that are disproportionate to the act. A conviction will be a felony, carrying an imprisonment up to 5 years, and as my colleague already stated, up to $100,000. Is that what we're in the business of doing, creating a new felony? House Bill 1076 will be elevating what is often a non-violent act of civil disobedience. This could ruin lives right here in Georgia over a single protest. There's redundancy in the law, and as already stated, it's a misdemeanor right now that can carry 1 year and $1,000. In this bill, 1076, is very vague language that can carry a very chilling effect. We're going to start criminalizing civil disobedience, peaceful protest, something that our Constitution warrants us to be able to have the ability to peacefully protest. What about bystanders? What about bystanders? There's a level of subjectivity in House Bill 1076. And in my closing remarks, Mr. Speaker, I'm starting to use ChatGPT. And I asked ChatGPT, my dear friends, I said, if House Bill 1076 was in effect today, what would be the results? This is what ChatGPT said. There is no recorded surge of police officers being killed by vehicles in a manner that existing Georgia law couldn't already prosecute. The significant disadvantage of House Bill 1076 here, Georgians will be subjected to a level of subjectivity that could ruin their lives with a new felony and fines up to $100,000 to address a statistical rarity that is not actually happening on Georgia's street. And then here's the amazing thing about ChatGPT, Mr. Chairman. It says, Derek Jackson, you should vote no to House Bill 1076 for a problem that doesn't exist. With that, Mr. Speaker, I yield the well.
You said that with spirit. Yes, sir. That concludes our speakers on the bill. Is there any objection to the previous question being ordered? We do have a minority report. Representative Holly. Representative Holly is the member that signed it, so you have up to 20 minutes, sir, to bring the minority report.
All right. Thank you, Mr. Speaker. I know the hour is late. Even to the point that sometimes I think that gavel, it rings loud and clear, but I don't know if it's getting people back in their seats. Hopefully you can because I would love for you to be able to hear from Representative Rua of Roman, whom I yield the remainder of my time. Thank you, Mr. Speaker.
The lady's recognized for up to 19 minutes and 30.
I'm used to being hungry. So, you know, I was reading this bill, and I've been thinking actually a lot recently about where we are as a country. And I am going to start with a story. I went down to Stewart Detention Center recently, where I had the opportunity to meet with 3 separate detainees. One of them has been living here for almost his entire life, was randomly picked up earlier this year, had been in there for about a month and a half, and frankly, he was still pretty shocked to be there. He was frankly still in denial. The other one was an asylum seeker with no criminal history. I don't think any of them had criminal histories, but either way, one of them was an asylum seeker, and the kind of case that you would think, okay, this is why we have the kind of laws that we do that allows us to welcome those that need us most. He would have been someone who contributes a lot to our communities, and he was terrified. I remember talking to him, and the judge had said that he was not deportable, and yet he was still in Stewart detention. They refused to release him. And the third story was about Rodney Taylor. Rodney Taylor is somebody that this body should have heard about, although no one really pays attention to afternoon orders apparently. And Rodney Taylor in particular is someone who uses prosthetics to get around, and unfortunately has not been getting the care that he needs. In fact, because a single guard had seen him stand up, they refused to help him get food. Other detainees had to help him by getting him food for weeks, by the way. They wouldn't give him a wheelchair. If he wanted to shower, if somebody was willing to help him shower, he had to crawl on the dirty floor. And there are countless stories like this. Stories of people I personally know over the decades, stories of people that I heard about from constituents. And why do I share this in light of this bill? Because I know there are people in this chamber that no matter what I say, it's never going to come through, and that's fine. But I also know that there are many in this chamber who probably never heard those stories. There are probably many more in this chamber who have, frankly, no idea what's happening in our own backyard. For example, did you know that Georgia has the 4th highest rate of detention, or of ICE detentions in the country? I didn't say deportations, by the way. I said ICE detentions. And why am I focused on detentions? Because this has become an entire industry. I need you to hear me when I say this. We have developed an entire industry that we are paying for to continue caging people because there is a massive financial incentive to make sure those beds are full. But if you look at our deportation numbers, they have not kept up with the number of detentions. And why is that? Because there's no financial incentives to actually adjudicate their cases. Many of the people that ICE is arbitrarily picking up end up released. And again, why am I sharing these stories? We have turned this into an industry. We have turned caging people into an industry. In fact, it's been an industry. We're just now growing its reach. We are putting people in cages that should not be there, including children, by the way, who we recently took away things like coloring books from. We've recently shut down health services in these facilities. We have recently taken away the number of judges available to adjudicate these cases and actually get people out. We have turned detaining people into an industry, and I need you to hear this because it is relevant to this bill. I need you to understand that no matter how much spin we're going to hear about this bill, this is what this bill is about. It is about making it harder for you and I to stand up for our neighbors. This bill is meant to make people more fearful to stand up for their neighbors. And I say this in a chamber of people that not even a couple of hours ago told me personally they didn't agree with a basic property tax bill and voted for it anyway. And when those consequences are simply political, you want to tell me that doing things like fining people for protecting their neighbors is not going to deter people from protecting their neighbors. I don't know, y'all. I think that when people are trying to do the right thing, the most basic part of our jobs is to listen to them, even if you disagree with them, even if you cannot see their perspective, even if you cannot understand what would motivate somebody, what would move them to stand between them and someone who does not see that person they're trying to take as a human being. Do you really think that it's evil and animus that moves those people? Or could it honestly be that we see some of the best in people in those instances? One of those people, her last name is Good. Her name was Renee Good. At bare minimum, shouldn't that make us pause and wonder if the propaganda that we are being exposed to is telling us something that isn't true? To me, that is the world screaming at us to wake up, to look around us. I saw even conservative commentators condemn what happened to Alex Preddy. People who have called me a demon, by the way. Because you do not shoot a man in the back for simply trying to stop an untrained ICE officer from pepper spraying another person that they were there with. He was protecting her, and he was killed for it. Does it not make sense that for once, we learn something? That for once we go, you know what, maybe I should look into this. Maybe I should wonder what could move people to put themselves in that situation. Because let me tell you what happened in Minnesota. Take away the spin for a second, because I know people there. And no, not because they're Muslim. I know people there because they're fellow elected officials, by the way. And they will tell you that the tear gas, the increase of ICE agents, the infiltration of their communities, it's still happening. But unlike, unfortunately, many of us here, they continue to show up for their neighbors, and they continue to be brave and actively speak out. And by the way, in a bipartisan manner. We have seen Republicans in Minnesota speak out for their colleagues instead of trying to pass bills to obstruct their own constituents from doing the right thing. I came home one night, and there was somebody outside my house, which for someone like me can be quite terrifying, by the way, but either way, it was an unknown car, and the person jumps out, and she is crying. Like, just absolutely crying, and I had no idea why she's at my house. Turns out she is one of my volunteers' moms, had seen an unmarked vehicle enter our neighborhood, and was wondering if they were there to take away her neighbor. And she begged me to come with her to figure out what's going on, and this was at night. I ran over there. Am I going to get charged with obstruction? Because I went to ask questions, because people are scared right now? People are terrified. I cannot begin to describe to you the fear that continues to permeate itself throughout our communities in this moment. It is not good. An officer killed a woman named Renee Good. Her last name was Good, and in our response, instead of saying, hey, we should be protecting Georgians and our constituents and maybe doing something about this, instead we're saying we are going to continue to vilify and feed into the vilification and, by the way, criminalize any kind of action that you take to protect your neighbors. That's not okay. It's unacceptable. But even more than that, even more than any of this, there is a world in which we can choose to actually do better. Because right now, down in Social Circle, there are people who are worried about what is going to happen to their town when you triple the population and try to shove 10,000 people into a warehouse. 10,000. Can y'all imagine 10,000 people in a warehouse? How many of y'all have been to a warehouse recently, especially in the summer? It is hot. Warehouses don't have enough bathrooms. They don't have enough showers. They don't have enough anything to be able to accommodate 10,000 people. That town doesn't have enough infrastructure to accommodate 10,000 people. What is the plan here? So again, I want to really tie all of this in for you, because we have managed to turn this into an industry where we are detaining people because there's a financial incentive to it, but we're not actually adjudicating their cases. They're not getting deported. We're putting them in a cage and letting them rot there. There's no way to amplify their case. There's no way to push their case. These court systems are so overrun that sometimes it's going to take a year or more just for a basic hearing. And even if it is deemed that you should not be deported, you're still going to have to sit there until they decide whether or not you can be released. It's easy to be able to say everyone's a criminal. That is easy. That's how propaganda works. Nobody, because I think that there's a lot of good in all of you. I'm often told not to believe that, but I actually sincerely do believe there's a lot of good in people. It is a belief of mine that I have seen day after day after day, even when on the most disappointing of days. But I need y'all to take a second. You can actually go and visit people at Stewart Detention, by the way. You can find people from your districts and go visit them and go talk to them. I urge you to do that. Because you are going to find out that we are being lied to. These people are not criminals. Creating laws to then criminalize people trying to protect them is a complete abdication of responsibility. In fact, we are enabling some of the worst horrors that I think we are going to look back on in our history. Because here's the fascinating thing about humanity. One day we are all going to look back. Many people are going to say that they have always been against this. Always. This is how people view slavery today. This is how people view Jim Crow. This is how people view just about every atrocity in our history. Where they look back and they say, this is awful. But the reality is there were people in that moment that enabled those horrible policies. There were people in that moment that made it more difficult to stand up for our neighbors, to stand up for what's right. Because what is legal is not always what's right, and what is illegal is not always what's wrong. We are literally creating a law right now that says if I see somebody who is being detained, by the way, in an unmarked car, because it's important to remember this, by the way. I talked about this last year. And a lot of y'all didn't believe me until I showed you the video. But when there is an unmarked car driven by a masked individual, and they're going to try to come at me, you bet I'm going to think I'm getting kidnapped. Are you kidding me? And you're telling me if I see that happening to my neighbor that I shouldn't step in, and if I do, then that's a felony? Do you not think that we have an obligation to protect each other? What is the point of being a neighbor? What is the point of being around people? And by the way, we have legislation that says ICE agents should identify themselves. We can vote on it today. We have legislation that says those unidentified ICE agents cannot enter a school or a house of worship or a hospital. We can move those today. We can actually help alleviate this tension and reduce so much of what we are seeing, that fear, that anger, that frustration, instead of telling people they're on their own and that they start to feel that their only way out of this is take matters into their own hands. We have a responsibility and an obligation to be leaders in this moment outside of partisanship. There are some things that should go above partisanship. I know that y'all are tired, and I know that y'all want to go to dinner, but, I mean, this came up as the last bill of the day. And I think that there is a point in which we have to talk about what all of this means and what we are doing and the signal we're sending to people. And to those of you out there that have been showing up for your neighbors, that have been caring for each other, I hope y'all know that no matter how many people tell you that there's no point, that it doesn't matter, it matters more than you know. I'm going to yield the rest of my time to Representative Neal. Thank you.
Ladies recognized for up to 5 minutes and 55 seconds.
Thank you, Mr. Speaker. I won't need that long. I wasn't going to give remarks, but and I know this bill is probably going to pass, but tonight I wanted everyone to consider the unintended consequences. I'm worried about the bad apples with this bill. I'm worried about the stretch of this bill. I know this body is trying to do the right thing, but we also have to be careful to not give bad apples any charge they can stretch. Stretching this code to fit, stacking charges, and arresting people that probably shouldn't be arrested is problematic. We don't want to encourage bad behavior by those that we are actually worried about. So with that, I hope you just consider as we move forward, and I think we have some more bills that are a little concerning as well, that we have unintended consequences that I would love to see us correct for. But as we move forward with this bill and others, we should always be careful to not give bad officers, not the good ones, but bad officers, the tools to do worse than they already are. And with that, Mr. Speaker, I yield the well.
Thank you, Representative Deal. The lady has yielded the well. That completes our minority report. Now we'll have the chairman's time up to 20 minutes. Chairman's recognized. Chairman Smith.
Thank you, Mr. Speaker. I'm going to yield a portion of the chairman's time to the author of the bill, Representative Jeannie Earhart, and the majority whip, Representative Burchett.
Representative Earhart is recognized to
Thank you,
speak to House Bill
members.
1076.
Thank you, members, and I will not be using 20 minutes. I will be using 2. I appreciate the thoughts that I've heard tonight, and I want to be very, very clear about this legislation, this proposed legislation. It is not about ICE. It is not about detainees. It is not about immigration. It is not about so many of the things that I heard spoken of this evening. This bill is about deterring dangerous behavior that puts people at risk. Not just our law enforcement officers, but folks that are engaged in the activity and innocent bystanders as well. I've heard talk tonight about individuals involved in very serious situations in other states that ended very badly. I have not brought up those situations. But I can tell you when we talk about deterrence, it's something to consider. It's worth noting. I heard someone from this body recently state in committee that we know deterrents don't work. And I would offer a correction to that statement by saying that weak deterrents don't work. Enhanced criminal penalties absolutely can be justified on a theory of deterrence. It is a solid and proven theory. Real-life examples, DUIs, felony classifications, license suspensions, and mandatory jail time have been associated with a long-term decline in alcohol-related traffic deaths on Georgia roads. How about domestic violence? Enhanced domestic violence laws and mandatory arrest laws have shown to significantly reduce the incidences of repeat domestic violent offenses. Deterrents do work. It begs the question, are our deterrents strong enough? Had deterrents been stronger, would they have dissuaded some of the decisions that were made that led to tragic circumstances? In the end, stronger penalties paired with consistent enforcement can deter criminal offenses. They can signal a shift in social norms, and they can reduce a tolerance for this sort of behavior. I would like to remind all of us about the issue of constitutionality. I've heard things tonight that are flat out wrong. This bill recognizes that we have the authority to enact criminal laws that protect public safety. The courts, including the United States Supreme Court, have consistently upheld laws that regulate dangerous conduct involving motor vehicles. We know that courts draw a strong line between expressive activity, meaning speech, protest, symbolic expression, and conduct that threatens safety or interferes with lawful duties. In closing, members, and in plain terms, a felony charge for using a vehicle to obstruct police is constitutional when it regulates dangerous behavior, not ideas, not speech, and it serves a strong public safety purpose, as long as the bill is clearly written, which this is, and applies equally, regardless of viewpoint, which it does. It fits within established constitutional guidelines. Ladies and gentlemen, I ask for your favorable consideration of House Bill 1076. And Mr. Speaker, I yield the well.
Ladies yielded the well. He waves. Chairman waves. Excellent choice. Excellent choice. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All those in favor of the bill will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? All members voted. For what purposes Representative Evans rise?
Thank you, Mr. Speaker. Parliamentary inquiry.
State your inquiry, ma'am.
Mr. Speaker, isn't it true that if the proponents of this bill are really intent on making sure that there is an intent element, that they needed to use the words that you're going to find in every code section that deals with a felony, which is knowingly and willingly, and not just the word knowingly, either knowingly and willingly or with intent to cause harm? And isn't it true that I hope that the proponents will fix this very real problem when this bill goes to the Senate, and until then I will be voting no.
I appreciate the lady's thoughts and her insight. Now, have all members voted? If so, Mr. Clerk will lock the machine. On the passage of House Bill 1076, the yeas are 97, the nays are 64. This bill, having received the requisite constitutional majority, is therefore passed. We have a couple of further actions, and then we're going to have some afternoon orders and announcements, and we'll be on the way. For what purposes Representative Wade rise?
Mr. Speaker, I move that the rules be temporarily suspended so that the bill may be read for the first time and assigned to committee.
Mr. Clerk will read the caption.
Unnumbered House Bill by Representative Wade of the 9th and others to be entitled an act to amend Part 2 of Article 6 of Chapter 2 of Title 20 of the official code of Georgia annotated relating to competencies in core curriculum under the Quality Basic Education Act.
On the gentleman's motion that the rules of this House be temporarily suspended so a bill can be read for the first time and assigned to committee, is there objection? There's objection. Gentleman move. Gentleman moves. Gentlemen, for what purposes Representative Wade rise again?
Speaker, I make a motion to withdraw, but I would like to comment to my colleagues on the other side of the aisle. This is a measure that you have been communicating with me for 3 years on. I've worked with several of you. I'm very disappointed, but I'll make a motion to withdraw begrudgingly, sir.
Measures withdrawn. For what purpose does Representative Gamble rise?
I move that the rules of this House be temporarily suspended so a bill can be read and assigned to committee for the first time.
Mr. Clerk, read the caption.
Unnumbered House Bill by Representative Gamble, the 15th, be entitled an act to amend Titles 20, 45, and 50 of the official code of Georgia annotated relating to education, public officers, and employees.
On the gentleman's motion that the rules of this House be temporarily suspended so a bill can be read for the first time and signed to committee, is there objection? Is that the governor's bill too?
This is a governor's bill, Mr. Speaker, and I regret that we have to do this, but I will withdraw my motion.
Motion is withdrawn. All right, before we get into afternoon orders, we have several of them. The following bills and resolutions will be postponed to the next legislative day. House Resolution 1049 and 1000, House Bill 421, 942, 334, 545, 626, 892, 1122, 1167, 1283, and 1116 will be taken up the next legislative day. Afternoon orders, Representative Griffin. Representative Ali, you're on deck. Chairman Saines and Representative Ford. Representative Griffin is recognized for an afternoon order. Give the gentleman your attention, please. Representative Griffin. I'm going to ask y'all to do it in a minute or so if you can. I hope you can. Give the gentleman your attention, please. We'll be out of here.
Mr. Speaker, today I rise not as a Democrat, but as a fellow soldier. We have learned of the loss of American soldier members during a military operation in the Middle East. Behind every headline is a human story. These were not statistics. They were our sons and maybe daughters, teammates, and neighbors, also Americans, who have answered the call to serve and stood to watch for all of us. As someone who has worn the uniform, flown into dangerous missions, and served alongside brave men and women in harm's way, I know there is no such thing as a routine deployment. Every mission carries risk, and every loss carries a lifetime of grief for families who gave their very best to this nation. And Mr. Speaker, this is no distance to me. Today, my grandson is serving in the Middle East. He represents the fourth generation of Army service in my family. So when we speak of sacrifice, we speak of families, families who pray, families who wait, families who live each day with both pride and concern. Today or tonight, somewhere in America, families have been received the most painful knock on the door and a family can receive. These soldiers did not bait policy. They did not sit in a chamber like this one. They executed duty. They trusted leadership. And their sacrifice reminds us that leadership carries responsibility beyond this room. Because of the decisions made in places like this are carried out in deserts, skies, oceans, and conflict zones by young Americans willing to give everything. So today we pause to honor their courage, we lift up their families, and we recommit ourselves to the seriousness of the decision entrusted to us. May we always remember, leaders solve problems, not create them. Mr. Speaker, if I may, let us pause for a moment of silence. Thank you, and I yield the will.
Thank you for your service, Representative Griffin, and we are prayers for your grandson, that he'll be safe, and all of our men and women in the military. Representative Ali, the gentleman is recognized for adoptable child.
Thank you, Mr. Speaker. Members of this House, it's been a very long day, but I'm sure we can all agree we can come out and carve out time for Georgia's foster children, such as Cameron, aged 8, who is a Lakers and Eagles fan while being caring, inquisitive, and a loving addition to anyone who chooses to adopt him at itsmyturnnow.dhs.georgia.gov. Thank you, Mr. Speaker. I yield the well.
Thank you, Representative. Chairman Saines, the gentleman is recognized.
Thank you, Mr. Speaker. On the board is what in-class instruction looks like after bats have infested the St. Mary's Elementary School They prioritized in Camden County in-class instruction and worked with Chancellor Sonny Perdue and the College of Coastal Georgia to ensure elementary students had an alternative learning environment to ensure education. So we're going to give Chancellor Perdue the BAT Award, Backing Academics Together, for their partnership, and this House has been very supportive of this unexpected $2.5 million cost to the Camden County school system, and we very much appreciate the state partnership. Thank you.
Thank you for letting us know about that. Don't go very far. You have an announcement. Representative Ford is recognized for an afternoon order.
I'll be really quick. Just couldn't let this day go by without wishing my sweet girl a happy 18th birthday at home. So if y'all will join me in wishing her a happy birthday. Anyway, what we do is important, but our children are most important. So thank y'all.
Happy birthday. 18, that's pretty cool. Chairman Todd Jones. The gentleman's recognized for an announcement. We're moving on to announcements now.
Thank you, Mr. Speaker. TII will meet in 341 right now. As soon as we have 8 people, which is quorum, we will commence the meeting. Thank you so much, Mr. Speaker.
Which room? 341. Chairman Saines, recognized for an announcement.
Thank you, Mr. Speaker. Thanks to the Trump administration, a new tool to communicate to our constituents is now available. A TikTok training sponsored by the Future Caucus will be a bipartisan effort happening tomorrow night, either upon adjournment or upon break in the Blue Room. We hope each legislator and their staff can join us.
Chairman Gunther. The gentleman's recognized.
Thank you, Mr. Speaker. House Judiciary will meet in room 132 at 8 a.m. in the morning. We have just a couple of bills. Hopefully it'll be quick, and we'll be out of there by 9 o'clock.
Representative Gamble, are you still? Oh, there you are. I'm sorry, sir. Representative Gamble is recognized for an announcement.
Thank you, Speaker. After today, like today, we need some prayer. In the morning, the fellowship will meet at 7 a.m. in House Judiciary. I hope to see y'all there.
Excellent observation. That completes our announcements. I'm going to recognize the majority leader of this House for a motion.
Thank you, Mr. Speaker. I move that this House stand adjourned until Wednesday, March 4th, 2026 at 10 o'clock a.m.
On the motion of Majority Leader F. Stration, this House. Yeah, I guess I better go back and do that too. So bring your sleeping bags. We're going to work late tomorrow night. We'll have some dinner for you, but we want to get some things done tomorrow as we lead into Friday and crossover. So be prepared to come in and make your plans to hang around a while tomorrow night, and we'll have dinner for you tomorrow night. As us country boys say, we'll have supper for you. So we'll have both supper and dinner. So with that, on the Majority Leader's motion that this House stand adjourned until 10 a.m. Wednesday, March 4th, 2026. All those in favor will say aye. Opposed, no. Not close again. The ayes have it. This House stands adjourned. Thank you, members, for your day.